Welcome to Syracuse. My name is Bill Banks. I'm the director of the Institute here, National Security and Counterterrorism. We're so excited about this program and what you're here to experience over the next day or so. We have some very brief openings, a couple of administrative things to attend to before I introduce Elizabeth and she, our first panel. Really, I think the thanks here and the introductions start at the very top. This university is about collaboration between programs and departments and people and ideas. And they've been very supportive of this institute and our colleges and the very program that we're here to engage in today. And it's my pleasure to introduce first the provost and Vice Chancellor for Academic Affairs at Syracuse University, Eric Spina. My friend Eric, who's been a member of the Syracuse community for more than 20 years. We've been collaborating since he was the Dean of the College of Engineering some years ago. He's been our provost since 2007, where he's been all about fostering the collaborative opportunities around campus. So, for the university, Eric Spina.
Thanks, Bill. Appreciate it. Well, it is a pleasure to welcome you all here on behalf of the Chancellor and myself. I wore a little orange today, specifically to remind you where you are. We're at Syracuse. We're not in Washington. We are actually very proud. It's the first time that this conference has been held outside of Washington. I understand that's a general movement, but really very proud that it's here at Syracuse, where we do have INSCIT, which I know you're all well aware of. It's been really led remarkably by Bill Banks, and been very strongly supported by two deans, by Jim Steinberg, who joined us last year, and by Hannah Arterian, who really have come together now over a number of years to make INSCIT one of really the embodiments of our vision of scholarship in action, which is really asking our faculty, encouraging our faculty, motivating our faculty to focus on problems that really make a difference in the world. And INSCIT really has, from the very beginning, been focused on important problems that really can make a difference. We believe we've contributed to that in meaningful ways, through Bill's leadership and the folks that he's brought into the Institute. And simply, as a university, we are very proud of the collaborative spirit in Law and Maxwell and across the university, the strong leadership that we've had in INSCIT. And I think the conference is very well titled in terms of the intersection of national security law and international affairs. It really is what INSCIT is about. The program looks fantastic during this weekend. I wish you really wonderful exchanges, and we wish you all the best for a great conference.
Thanks, Eric. There wouldn't be an INSCIT without Dean Hannah Arterian of the College of Law. When she arrived here, is it 11 years ago now, I was minding my own business, doing this work with my co-authors and friends and colleagues, and she said, you know, we really should get something out there for the school, and this is an important field, and I know you're all well and good, but with her knee very firmly in the small of my back, she urged the creation of an academic program, and we did it. You see the logo and some signage around. This is our 10th year, thanks to Hannah. And it didn't take long. Within a year, it became a two-college program between the College of Law and the Maxwell School, and here we are. We've matured, I think, and grown, and we're doing better stuff all the time. Thanks to a tremendous staff, a lot of collegial faculty, tremendous decanal support across the colleges from the provost, and amazing students, graduate students and law students, many of whom are in the room here today, some of whom picked you up at the airport, and they're a full-service bunch. They do it all. So, Hannah, would you say a few words, please?
Sure, I'm happy to. As usual, I'm in the wrong place. I should have been sitting over there, but I won't let that stop me. First of all, welcome to the College of Law. and I hope that you all will find your time here extraordinarily rewarding, as I think is inevitable given the program that you have before you. And I also am very grateful that so many distinguished academics and practitioners are here to participate in this. It's wonderful to see after the 10 years this group here, because certainly this is exactly, I guess, what we would have hoped for when the Institute was founded. As Bill mentioned, I've been here, I'm in my 11th year, let's just put it that way. And it's also true that I noticed buildings before I got here. And then I got here after 9/11. And not surprisingly, his work became even more compelling than it was before then. And he became much more engaged in all kinds of things besides the very serious work that he was doing before that time. And it's not, Phil and I had this idea together. It wasn't as if I just, let's be honest. And I think that one of the things, he mentioned so much of what's important about this institute, but I do want to emphasize, if I can for a minute, the students. I think I've traveled to a number of law schools. In my experience, we have a unique opportunity here with the students as graduate students, because they not only take classes together, they work together. They work on projects together. They get to academically know each other. They get to know each other deeply intellectually, and I think as a result, they graduate from our programs with a much richer understanding of what has to happen for policy and law to work together. And I want to say that because I think that's a hallmark of the work that Bill has done. So we're here celebrating the 10th anniversary. I want to also say it's been terrific to work with the Maxwell School, and it's been a truly wonderful thing for me as the Dean of the College of Law to have Dean Steinberg at Maxwell, because I think that is another force that's going to push this important endeavor together. I'm also just beyond thrilled that we are able to partner with the Standing Committee on National Security. This is a great moment for us, and I hope that the conference will be a lasting good memory for you.
The Standing Committee on Law and National Security, the ABA, is also having a banner celebration this year, the 50th, which is coming up formally at an event in November of this year. It's been a phenomenally active part of the ABA over 50 years. Perhaps the most prominent founder is Justice Lewis Powell of the United States Supreme Court. So we look back a ways, don't we, Jim? Representing the committee as its chair here today is Jim McPherson, who, in his day job, is the Executive Director of the National Association of Attorneys General. Jim is also a national security professional, and in his last position in his career in the Navy was the TJAC of the Navy, where he served until retirement. It's old home week for Jim in part here to see his former colleague and INSCIT Deputy Director Bob Moret, and to combine forces here at INSCIT with the Standing Committee is a real treat. Jim, thanks.
Thanks, Bill. Let me echo the good afternoon and welcome to everybody. And thank you to each of you for taking time from your very busy schedules to join us on this very gorgeous and, dare I say, fall day here in the beautiful campus of Syracuse University. If you're in this room anticipating a gridiron event, please don't leave. That's tomorrow, so you've got plenty of time to stick around with us this afternoon and listen to a couple of very interesting panels. Harvey's at about 30,000 feet right now, but will soon be making his final approach to Hancock International Airport, where we all came in. So he'll be here in a couple of hours, but meanwhile, he wanted me to just say a few words on his behalf for the Standing Committee. As your program suggests, this is the third annual conference on teaching law and national security. The first one we have taken on the road. The idea for this conference series was hatched about 4 years ago, and then was nurtured and grew with the attention and dedication of several, but none more than Professor Bill Banks. The first two conferences were held in Washington, D.C. Last year's was hosted by Georgetown University Law Center. When we decided to take the conference outside of D.C., Bill said, hang on just a minute, I have to make a phone call. He called, I'm sure, his dean. Actually, I think he called Marlene. Got permission to bring it here, and so Syracuse is the first time we're outside of D.C., and we're very thrilled to be at this terrific training site. But not only did Bill offer the facility, he rolled up his sleeves and together with his tremendous team, took on the challenge of organizing what I am certain will be an unparalleled conference. Bill suggested the next advertisement I'm going to give, and that's for our 22nd annual review conference. It takes place on 29 and 30 November in Washington, D.C. Our website is up. Registration is open. When you get a chance at the break, please visit and register for the conference. It's a terrific opportunity to network, to hear the latest from panels in the substantive areas of the law of national security, and it'll be just a great time. By the way, there's CLE offered as well. So if you're a law student and you can make your way down to DC, please come on down and join us. We are co-hosted this November by the University of Virginia Law School, Georgetown Law, and Duke University School of Law and their various legal centers. My brief welcome is about it. But let me conclude with a very heartfelt thank you to the Provost, to the Dean, and most of all to the Institute of National Security and Counterterrorism, Bill Banks and his terrific team, and to Marlene, without whom this would not be possible. So our round of applause is for Bill and Marlene. Thank you very
much. Well, let's get on with the show. You've all seen the web materials. You know about the theme of the conference, the intersection of national security law and international affairs. And as you know, this has just been another week in national security, hasn't it? From the tragic events in Libya a few days ago and the death of our ambassador and staff there, to the continuing protests around the Middle East and the Muslim world that are still fomenting today. The findings earlier in the week from intelligence agencies that Iran had made yet more progress in developing its nuclear program. To the House of Representatives passing the 5-year extension of the FISA Amendments Act a day or so ago. To a federal judge in I think it is in the Southern District of New York, enjoining provision of the National Defense Authorization Act relating to continuing military detentions. It's a normal week for us. It's a momentous week. We're here to talk about just that kind of topic and to dig in great depth. We do have tremendous talent here in the room, and we're going to begin with the first panel. Dean, and I'm going to always call you Dean, Elizabeth Parker, who has just stepped down after a very long, successful deanship at Pacific McGeorge University in Sacramento, is now enjoying in her usual frenetic fashion a year of sabbatical, working probably harder than she did even while she was dean. She was kind enough to take the time to come up and join us here today. One of the reasons that Elizabeth is sitting as the moderator and indeed the anchor of this first panel is that she has been in all of the places that we are talking about today. She was General Counsel of the National Security Agency, General Counsel of the CIA, and Principal Deputy Legal Advisor to the Department of State, among other prominent positions in government and related organizations over the years. There's no one that knows what we're here to talk about more than Elizabeth Scott Parker. Would you introduce your panel, please?
Thanks, Bill. This seems to work very nicely, so I'll just sit here, rather than, as I'm tempted to do, stand up to see if I can keep this fabulous panel in line. With everyone else, I have to say that, Dean Arteri and Hannah, you've just been wonderful in the support you've given Bill. You saw a treasure. Bill and Peter Raven-Hansen, Steve Dicus are really responsible, I think, for making national security law the important academic subject it is today. Personally, I'll say that one of the reasons I left national security practitioner positions from a checkered career, by the way, where certainly I couldn't have spelled national security when I arrived at NSA, to go to the academic side was because I thought this was such an important topic. And it seemed to me that our National Brain Trust, the practitioners, and the academics were not speaking with one another as effectively as they might. And this institute then is a solution, or part of the solution to that problem. And this audience, which I am hoping, I'm tempted to ask for a show of hands, includes both current faculty and future faculty, students who might look in that direction, is probably as important an audience as our nation could have when it comes to national security. One thing Bill didn't say is that, notwithstanding I'm rather long in the tooth when it comes to national security these days, is that I remain on the senior advisory group of the DNI, where I've been for the last 7 or 8 years. And as recently as last week, once again it came up that our nation really still does not thoroughly grasp what this new national security paradigm we look at means, and that much of that knowledge and understanding has got to happen in our law schools. So those of you who are now or will be preparing future leaders, that would be coming from our law schools, this is a valuable and important topic as we can think of. Enough about me. Let me say just a word about this remarkable panel. Now, I have a dilemma here. I can introduce them, and that might take the time for my panel, or I can refer you to the program bios, which appear on the web. I'm going to do the latter and then just point out a couple of things as to why this is such a valuable group to have with us as our first panel. Moving from my left to right, we have first Mary DeRosa. I'll simply say that Mary, a graduate of GW with an undergraduate degree at Virginia. I do know we're an academic institution. I want you to know, Hannah, that these people also served for 6 years in 2 separate administrations as among the most senior lawyers in the country at the NSC. If that doesn't give her credibility, I can't tell you what might. Joel Brenner, moving now to my right, occupies an interesting position on the panel because, unlike Mary, he can't claim to only have been a lawyer on national security topics. He also has a foot in the other camp. He did some policy work as well. And so, notwithstanding a background in antitrust, and I should say by way of academic pedigree, a Harvard Law degree with a PhD in legal education history?
Legal economics.
Economics, sorry. I was hoping it was education. Never mind. From the London School of Economics. He actually was an antitrust practitioner. Later on, ask him how he got from antitrust to national security. I gather it's an interesting story. But at NSA, he was actually the Inspector General initially, and then went on to be senior counsel, and then moved into what I would say is really an important policy role with the new Director of National Intelligence, managing counterterrorism.
Counterintelligence.
Was it? Oh, I'm sorry, I got that wrong.
Counterintelligence.
All right. Across, would you agree, 17 agencies, or is that number wrong?
No, that's right.
Okay. You can see this is not a timid panel. I did not have my prop or my little, what do I say, my whistle to keep them in line, so I'll just have to do my best with this mic. And finally, we have Richard Falkenrath. Now, Richard is another one of these multiply disciplined people, but he is not a lawyer, so I'm going to put you in the policymaker seat today. But I'm not just going to leave you at the national level, because notwithstanding that you were the Deputy Commissioner for Counterterrorism, but I got that right, at DHS early on, after being the senior advisor to the president.
Deputy Commissioner of Counterterrorism with the New York State Police Department.
I got that one. Okay. So anyway, here we go. Spent significant time advising the president, that would be President Bush in the first administration, I think, then moving on to Homeland Security. But I think for our conversation today, I'm going to ask Richard to put on his hat on the domestic side, where remarkably he was the Deputy Commissioner for Counterterrorism at the New York Police Department. Now that's not a position historically we think of as being one in a large police department. And the story there I think is quite amazing. Richard has an undergraduate degree, he's a West Coaster, I'm gathering, from Occidental, and a PhD from King's College, and spent time in the academic world at the John F. Kennedy School at Harvard. So, with that rapid horseback gallop introduction, I want to begin by taking advantage of the tragic events of this week. And let me ask each of the panelists just quickly to say, here we are in a situation talking about translating legal advice into policy, how it actually happens. And we confront a situation where across the Middle East, events are occurring, probably even as we speak, that are raising legal and policy issues. Would each of you give us just a very quick comment on what you think the issues are? What's it like? Mary, I want to start with you in each of my questions because I might have subtitled this panel, what does a good lawyer really need to tell her policy client? And if Richard goes first, Mary will know the answer. So Mary, start out by telling us a little bit about what you see as the issues.
Well, I think if I think of what the lawyers who are dealing with the crisis in the Middle East right now, what they're dealing with, I mean, the first thing I think is that it's in crisis situations, particularly a situation where Americans are being killed or in danger, that is in the press around the clock. There's just there's a certain atmosphere, and I think one of the biggest, most important roles for the lawyer is to keep your head. There are going to be 1,000 ideas being thrown around. Some of them not, maybe the best ideas in the world, and the responsibility and the role of the lawyer is, among others, is to try to kind of lead a way. For example, I would guess, I have no idea, but I would guess that there were a number of thoughts bounced around about what to do about the video, and ways in which to try to pull the video down, or some ideas might be out there. I mean, talk about a situation where you really don't have a lot of options, legal options. The lawyer needs to be there. The lawyer needs to sort of, try to make sure that that people understand the constraints, and it's not always an easy thing to do. Other issues that they're looking at now. I mean, I'm confident that there are issues with evacuation, how to evacuate, use of military, and there are legal issues throughout. I think I heard on the news this morning that they have captured, or they've arrested some people in Libya. If in fact these are some of the perpetrators, there are going to be a variety of issues of the authorities under which to hold them, how to handle that. I would imagine if there's if it turns out factually that there's some AQ involvement, then that raises a lot of.
Let me tease out a little bit of the factual context you're talking about. You said the lawyers are there, but we all know that the way law is practiced is you put a nickel in and you get an opinion out. They sit in their offices. Where are you suggesting these lawyers are?
Absolutely, they're at the NSC, where I've spent most of my time, and I believe in all of the national security agencies. The lawyers are in the room with the policymakers. They need to be in the room with the policymakers who are batting about these. At the NSC, there was a lawyer, me or one of the people working for me, in virtually every policy meeting, National Security Council meetings, PCs, DCs, and all of the many informal meetings where policy is developed. And the reason for that is, and the reason that's just incredibly important, is that the lawyer can't be, if you try, you can't entirely let them figure out what they need you to answer. You need to know what they actually need. I know that'll get a lot of eye rolls, but in fact it's, that you need to, the lawyer needs to not just answer what they're asked, but try to understand the context and what is needed, because if the answer to one way is no, you need to find it, you need to find another way to get there if there is one.
So let's go to you, Joel. And maybe you put your hat on as Inspector General, because the Inspector General, of course, is going to follow on after it's all said and done and find out how they did it wrong, right?
Well, he might, actually, but let me even throw in one earlier than that, because you get in the room with the National Security Advisor to the President, and somebody says, we want more intelligence. Why don't we have more intelligence? And then somebody pipes up that says, well, sir, we actually did collect we had tremendous collection against one of the guys in the Muslim Brotherhood in Cairo. And it really lays out the whole network of who we want to get the Egyptians to roll up over there. But we have this lawyer who's actually has a joint degree from the Syracuse College of Law and Maxwell, and he says that he's told us after the fact that guy is a joint Egyptian U.S. citizen, and he's a U.S. person, so we've had to really throw that all away. And everybody in the room's got their jaws on the floor at that point, right? And so that becomes a very difficult sort of issue, that there's been some collection that, in some sense, though clearly inadvertent, look like it shouldn't have been undertaken without a FOSTA warrant. What do you do? And that, you don't want to have to say that for the first time when you're in the White House. You'd like to find that out early. That sort of thing really does happen. And one of the things you'll then do is go get a FOSTA warrant and put it up on those people. But what do you do with that information that you really wish you'd like to have?
And what's your answer?
Well, I'd be the Inspector General. I'd come in afterwards and tell you that. In that kind of situation, I don't think that information's going to go away. I think you're going to find a way to keep that information. And then, but that's very hard because the stuff has been inadvertently but incorrectly collected. That kind of problem does come up. I don't want to say it comes up a lot, but it is happening. It is happening.
We'll come back to that, but I want to get Richard in the conversation here, and I've asked you to kind of put your NYPD counterterrorism hat on. Would you do that and say a bit about what your reaction?
Sure. I mean, so my two roles were at the White House for 4 years and the NYPD for 4 years, and saw this from a number of different vantage points. In this particular case, with the killing of an American diplomat in Benghazi, the U.S. ambassador, it's a pretty straightforward matter. These issues today are a lot easier than they were 11 years ago. The machine is relatively well oiled because we've been at war for 11 years and there's just so many foreign contingencies. Most of what the U.S. government will have to do right now in the midst of a set of really difficult situations is in the domain of policy and doesn't require a lot of legal advice, though they're always there. Shortage of lawyers in the White House meetings, never a problem. I mean, they're always around. But the one insight here I might offer is that what happened in Benghazi is a crime scene. And the procedures that are actually quite well established, and whether they're executed or not depends on the permission of the host state, is an FBI flight team goes there and processes the crime scene. And they know how to do it. They need permission of the host nation to go there. So some diplomat will have had to go to the Libyan government and said, we need a team to come in, 4 U.S. citizens just been killed. We want to process it in anticipation of future prosecution in the U.S. court. The one interesting, that Mary alluded to this is downstream. If there ever is an arrest, there is a kind of political question now about how to handle that individual. And almost every lawyer in every room will say, well, of course you indict them in federal court under whatever statute you can do, and you make the case and lock them up. But someone who's not a lawyer, or maybe they have a law degree, but is mainly politically oriented, will say, well, God, we've been getting a really hard time about that from our, the other side of the aisle in Congress. Maybe we should try them in the military tribunals and call this an act of war. So they'll have to debate through that. I actually think that's a pretty, from a legal standpoint, straightforward matter. I mean, if you have a case on the perpetrators of this act, you're going to indict them in federal criminal court. But you do have to build the case, and there's tons of lawyers involved in that. And that part of the government knows how to do it. I mean, it's just they do it all the time. I mean, doesn't require a lot of policymaker intervention if they ever get someone to arrest. If they don't want to take custody of them, the third option, which is what we do a lot in the last 11 years, is you turn them over to the host nation government, let them dispense justice. And that, sometimes the host nation requires that, which was the case in Syria where another U.S. diplomat, Sudan, where another diplomat was killed. The Sudanese just wouldn't give them to us, even though we know exactly who did it, had the rights. They tried and got a light sentence. But the Libyans, my sense is the current Libyan government would hand these guys over if they wanted, and then we'd have a trial.
Well, now, Mary, let's check on your view here. Do you think it's the law of armed conflict that applies, or is this, in fact, simply a criminal matter happening overseas?
I think it's overwhelmingly likely that it would be a criminal matter, but I think it is absolutely true that question is going to come up. Now, if particularly if there is an AQ connection, but if there is some terrorism connection generally, I think there's no question that those are, whether we should, hold them under the law of armed conflict, send them to military commissions. Those questions will come up and need to be dealt with. I think I agree with Richard that likely the answer is going to be that they will be sent into the civilian justice system.
Well, how does the situation change if indeed we do decide this is an act of war and the law of armed conflict applies?
Well, you still have both options, and it's which makes the most sense. I think the biggest issue is if there is some issue of the need to interrogate and how will it come out? Your question is how would it come out? I think my prediction would be that it would come out in the way that Richard suggested for that. I think it would be more of a discussion maybe than Richard suggested.
If I may, I don't think the interrogation is the issue because the current military tribunal process doesn't have interrogation processes that are all that much superior to just interviewing someone who's already lawyered up in court. So I don't actually think it makes much difference. It was different. It might have been different for the black sites in the CIA detention program, but these days, the military tribunal process, that's where they're processed, whether it's in Bagram or in Guantanamo, where they're not doing any new admissions, it's not significantly better in terms of
that is the rational answer, I think. But it's not just about military commission and is there whether I think there could be a question, and there has been in one case where we held somebody under the law of armed conflict for a while, or SAMI on a Navy vessel, and then turned them over for questioning, and then turned them over to the civilian justice system. And I think that could very well be something that's being discussed. This all assumes there is some basis under the AOMF and the law of armed conflict to do that. But and factually, I just have no idea whether that's the case.
Now let me throw in this question. I'm the policymaker for the moment, and I have just spoken with someone just back from Tripoli, and what I've been given to understand is that there's absolutely no security on the ground there. It's really quite a lawless place. And I gather what Richard is telling me is that I'm going to send over an FBI team of about 38. Well, who's going to protect them? Am I really going to be sending them over to do forensic work and then have a whole additional group victimized? Wouldn't I be better off just saying, well, this is a case where the law of armed conflict applies, I'm going to send in the military, and we're just going to deal with anybody with the use of force at the beginning, not the end?
Well, you might not have the facts for that, and I believe we actually already have sent over a team, an FBI team.
It's automatic. I mean, it is close to automatic. If they weren't there, I'd be amazed.
What do you think, John?
Yeah, I agree with that. I think I'm right. The military people in the room can holler if they disagree. But I think the FBI is just the best, and much better than the military at crime scene investigation. That's what they do. They're really good at it. I think that's who we'd want to have do that.
Let me ask the final question. Using the current fact situation that's evolving, obviously, as we speak, what do you think the changes are? I'm hearing a little bit of this in this situation versus what we all paid attention to in 9/11. Are we in the same position we were then, or is Richard exactly right? We've had enough practice going along in the last 11 years that much of this is going to happen automatically.
I agree with Richard on that. I think that at least, I mean, if this law of armed conflict, the AOMF issue comes in, it's complicated. It would not be automatic, but there's a great deal more experience, and the law in that area and the practice in that area have developed tremendously since 9/11. So I think that might be hard, not automatic, but a lot easier. And in every other respect, I think that we're used to crisis.
I can think of only one fact that would really complicate it and that would light Lindsey Graham up. And that would be if we were to learn that this operation had been planned by an Al-Qaeda cell. And if it had been planned by an Al-Qaeda cell, the argument for treating this as an act of war becomes really quite strong. And then I think we have a very robust debate.
If I may, I know you're asking me to contradict myself here.
You want to put your national security hat on?
No, you said, I actually think it will be less a kind of investigative forensic question, like, in their heart of hearts, what did those people who carried out this terrible act, who were they aligned with, which is sort of, on any given day they could be aligned with. I think it will actually be more operational. So if the crime scene develops in such a way that there actually is an investigation and there's a local security force with which our criminal justice agents, the FBI and their associates could work, they'll try to do it. But if you guys or NRO or someone comes and says, hey, there's a Jeep driving toward the border with Molly, and the FBI guys can never reach it, but boy, we have a SEAL team here on this aircraft carrier, they'll just go blow them up. I mean, this president, Mary's right, has both options. And if this president has a perfect record and is now very practiced at making these decisions about when to use lethal force outside of the context of the criminal justice system. And evidently someone's written memos that says he's permitted to do that. And he does it, and he makes the call like that. And, I actually commend him for that. And I think that's the other option. But it's the facts on the ground, it's the operational situation. It's just whether it presents itself or not that's going to call it, not the investigation.
So your point is it's not either or, it's both and the facts as they develop will determine.
I like the way you started with client, and the phrase that the way we construct this panel, translating legal advice into policy, I always put it as the reverse. Whereas it's lawyers' advice to translate policy into reality. So I'm the policymaker, or you are, the president is, and I want to get those guys. So your job is just tell me how to, I could arrest them and get them extradited back to me, there's one option, but maybe I can't, they're driving, just tell me I can do it, and we'll do it. So, I'm the client, you're the agent, I tell you what I want, you tell me how to do it, and whether it's law of armed conflict or criminal justice, the policymaker doesn't really care. Just, I want to do what I want to do and make it possible for me. If it's against the law, tell me, stop me there, because I don't want to break the law. But if you can construct a theory that makes it permissible, just articulate for me and let me go.
So Richard's done a nice job of moving the panel along to the conversation that I really wanted to have next, which is talk to us a little bit about the relationship of lawyers in the NSC, Mary, both to their client and to other lawyers throughout the government who are in the intelligence and law enforcement. And as I said, the relationship with the lawyers and the policymakers, in my experience, is quite close in that, the lawyers are really in the room a lot. I think my experience is that policymakers say they hate lawyers, but really, really love lawyers.
Which administration did you work for?
And in the sense that they don't want to bring, they want to do things right, but I agree entirely with what you just said, and is the way the process should work, and that is, lawyer understands what the policymaker wants to do. Lawyer, figures out not sort of a purely advocacy role, not a purely you want to do that, I'm going to find you whatever the best argument is, and we're going to get it done, and I'm going to give you cover. That's not the role, but neither is the role of sort of rigid, just as the law is, or no, you can't do that. Give me another question. It's somewhere in the middle, and that so my experience at the NSC is you're very engaged with the policy process. You try to be as on top of what is actually policymakers are trying to do as you can, and then the NSC lawyers work constantly with the lawyers in the State Department, the Defense Department, the CIA, the United States, the Justice Department, etc., to try to make sure we all understand the question, make sure we all are getting together and agreeing on the answer, and trying, at least my view was, to get the law out of the way as much as possible. Make sure you have the answer, not have lawyers disagreeing, not have policymakers having to sit in meetings where, one says, well, my lawyer says this, and try to reach a general view among the lawyers, and and if certain things have to be kind of cut off as options, do that, make that known to the policymakers, and get the next question.
So you're describing a team sport of lawyering, I think.
Absolutely.
And I'm wondering whether the legislative lawyers are on this team as well. I think in the panel, you're the only person who's had time on the Hill.
Yeah, the answer has an easy answer, no.
No.
I mean, I don't mean to be glib, I mean, it's just a different, I mean, the certainly the executive branch works with the legislative branch, but it's really a kind of a information, briefing, what's going on. The White House has less interaction with the Hill than the departments and agencies, so I just speak for the embassy role. But I wouldn't be in conversations with, unless there's legislation that we're talking about, I wouldn't be in conversations with lawyers on the Hill in the middle of an operation.
What do you think, Joel?
Not
right?
in a million years. I mean, first place is a separation of powers issue. But those guys are not your friends when you're doing operations. They're just not. And you're gonna find you have leak problems, and people with a different point of view. It's not their job. There's a separation of powers. Not in a million years.
And what do they think?
Oh, I think they don't expect to be there.
They don't. All right. Is that your experience too, Richard?
Absolutely. There's one possible exception might be a gang of 8 or gang of 12 notification.
Ah, that's a notification.
Right, and it's not with the lawyers, it's on the
Right.
principal level, but it's one area where there is a little bleed over.
Right.
Maybe you should unbundle that a little bit. You may have lapsed into code for some in the room. I think it's a pretty knowledgeable group. What's a gang of 8 notifications?
In the, you could describe this as well as I could or better. It is when you're doing covert action, in particular, in the National Security Act of 1947, one if there is an option you're supposed to, the preferred process is to notify the intelligence committees before carrying one out. But if there, for some reason, the president thinks it needs to be, that notification needs to be narrowed, there is a gang of 8, which is the chair and vice chair of the intelligence committees and the, no, it's the leadership. It's the speaker and ranking, and the leadership on both sides of it. In the House and Senate.
I see. So the president's asking their approval.
No.
No, the president is notified.
He's notified.
And what if they say we don't like this?
So they can go pass a law that says he can't do what he's about to do.
I see.
I mean, that's right. I mean, as a practical matter, if they really kick up a fuss, that's going to be, people have to pay attention to that. But in fact, they have no.
There was a case like this actually where I think it was, I don't remember this, I'm trying to recall, it was a sealed objection I think Senator Leahy had to one of these things, which was exactly your question.
Senator Rockefeller.
Rockefeller, that's it.
Mary worked with Senator Leahy, that couldn't happen,
Yeah,
right?
yeah. That was before it.
Was this on the surveillance program?
No, it was on, I think it was interrogation.
Okay, so
Oh,
John,
no, it might have been, you're right, but I think it might have been the
Right.
surveillance.
let's come to you for a minute and just ask a little bit about how you see the role of the DNI in all of this.
Can I?
No.
Can I go back just a minute? I'm happy to address the DNI, but Mary sort of sketched out the sort of legal illusion fields where the policymakers and lawyers are getting along around the campfire and everything. And I like to, because I want to enlighten how not to do it as well. I mean, and I had a really startling experience along those lines. I was the National Counterintelligence Executive and in charge of the counterintelligence aspect of the comprehensive national cyber initiative in the late days of the Bush administration. And through enormous effort, we got into one room in the executive office building next to the White House. Not only White House staff, but DNI, CIA, NSA, I mean, everybody cross-departmentally. And these are very difficult meetings to have. And we were meeting this is a wonderful building. Some of the students may have one day in their career have the privilege of going into this building. And we're sitting in what used to be the Secretary of State's office. It's a 30-foot high ceiling, it's gilded. It's really beautiful.
The old executive office.
The old executive office, now known as the Eisenhower Building. And it had been Elihu Root's office, I noticed on the way in. And we're sitting around, and a significant legal issue comes up. And there's a Justice Department lawyer there, and who we wanted there, but wouldn't sit at the table. She was sitting against the wall. And because she didn't want to be at the table. consequence of that, because it was, as her paradigm was put in nickel, get out of it. And a number of us turned around and looked at her and said, well, what's the Justice Department's view on that, and could you work with us to make this happen? Oh, she said, tell us what you want to do when you're done, and we'll tell you it's okay. And, you know, we'll tell you if you can't do it. And I was steamed and swiveled my chair around, looked at her and said, you know, we're in Elihu Root's old office. You know what Andrew Carnegie said about Elihu Root? He said, Elihu Root's the only lawyer I've ever met who tells me not what I can't do, but what I can do. That's what we need from you.
Go, keep going.
You want to disagree with him, Richard, otherwise?
No. She said, oh, we don't do that in the Civil Division. Okay? This is how not to become a powerful or important lawyer in your career, whether you're in the government or the private sector. This is how not to do it. I mean, your job is to get your client to yes if you can. And if your client really knows that you know that, the client will take no when you have to say no. And if the client doesn't believe that, the client doesn't take no when it's time to say it. And I still can't think of this incident without becoming really mad as hell.
Richard, I sense you want to comment.
No, I think how not to do it can be very instructive. I had a lot of experience like that too. First, the government is far too full of lawyers, just like Joel describes. I mean, and maybe they're in the private sector too. My guess is that if you actually have to make money, you get rid of them. But the government, they stick around, and you just encounter them. And within a few minutes of a meeting, you know, oh my God, this is just a pure oppositional person versus someone who might be constructive. I started on the NSC staff in January 2001. Pure rookie, straight out of an academic position at Harvard, had never been in government at all. Steve Hadley was my boss, quite seasoned individual, also a lawyer. And we sat down in the transition office room and said, Rich, you're about to be, go to the White House staff, and you're about to be running a bunch of interagency meetings. So I want to give you a little bit of advice. I said, okay. He said, well, number one is remember you're representing the policymaking process. You need to bring it to consensus, which is important. But number two is there's going to be a lot of lawyers there, and the most dangerous thing is a lawyer doesn't know who his client is. And make sure they all remember it. And the essence to a good lawyer is a good client. And the client has to be enough of a subject matter expert and have enough clarity about what they're trying to make it a very constructive interaction where they're not so completely overawed and overwhelmed by the superior subject matter expertise of the government lawyers that they can actually get to where they want constructively. This led to my second maxim, which another mentor of mine gave me, remain the nameless. It was along the lines of war is too important to leave to the generals alone. It was national security policy is too important to leave to the lawyers alone, meaning someone else had to come in and say, this is where I want to get to. Now, it can go wrong and badly many times, and I think the administration I served in has a number of examples for that, so by no means error-free.
So Richard, you've done a nice job of describing what a good lawyer looks like from a client's perspective. Let me break this down a little bit and ask two questions. The first would be, what does a good client look like from the lawyer's perspective? And I have my own answer, so I'm going to chip in at the end.
Well, I think a good client is one that is first of all, not entirely hostile. They might sound hostile because they always sound hostile, but in fact, wants to get it right legally as well, and understands that lawyers need to understand the facts of where you need to go. I mean, part of and this isn't true of the situation you just described, but it can be the case that if you don't have a lawyer in the room and you just ask a question without context, it's going to be very, very difficult to get a good lawyer around that. So a good client, wants you in the room and listens to you, but doesn't, but there's a back and forth. I mean, one, and you might not believe this, but one kind of thing that I actually, and I've talked to other lawyers, and we've seen particularly when you're getting at kind of new areas and novel issues that are really hard, is sometimes that the clients actually kind of look to the lawyers a little too much to say, well, what can I do? And I think there's a little bit of a chicken and egg, but I think the lawyer has to push back and say, what do you want to do? I mean, and And I shouldn't be creating your policy framework. And it sounds like you guys both agree that that's what the client should do, but there are sometimes when there's just a sort of insecurity on the part of policymakers, and they look for the lawyers to step in, and that's not healthy. That's not a healthy dynamic, and you don't want them to do that. So I guess that's.
So Mary sounds like a lawyer you might like.
John, do you want to comment?
Yeah, I mean, one of the things a good client doesn't do is feed you information in a centimeter at a time. This goes to your point, Mary, about giving legal advice in the abstract. Black letter question gives a black letter answer, but it's not necessarily a useful answer. And of course, if you're the general counsel of something or other, general counsel doesn't just mean you're the legal advisor. It means you're giving general counseling. Then you are often, depending on the organization, sometimes in a powerful policy role as well, and you're the consigliere to the chairman or the secretary or whatever it is, and so you've got to be particularly careful to understand what you do.
I think the distinction of types of government lawyers is very relevant here. I think Joel's absolutely right. General counsels play a different role than DOJ staff do, than the NSC staff does. And even there's an even more inner circle than the NSC staff, which is the counsels of the president. And the NSC staff actually has a separate statutory function and does things that the counsel of the president doesn't, but the counsel of the president under Title III does all sorts of things that the NSC staff doesn't have to deal with. I will say there's one, there are 2 points to Mary. Lawyers aren't in every White House meeting. So there are lots of meetings with no lawyers. And in part, especially some of them, they're just pure political calls or whatever, where they're just not there. They're not in every meeting with the president, though they are in basically every DC and PC I attended and observed, but they're not always with the president. And second, experienced policymakers learn where they need lawyers and don't. So there are some things which you just kind of know right off the bat requires a lawyer in the room. There's others you know are clearly within your kin to do. The one really big issue that happens only in time of war, it happened after 9/11, is colored through and lawyers spend the most time talking about it, but it was the decision to essentially try to accomplish more at war under the president's inherent constitutional powers as commander-in-chief. And there are lawyers undoubtedly right. That's a huge body of scholarship, but it wasn't a legal analysis that led President Bush and his principal officers to try to do that. It was just they were tired of dealing with Congress. They felt they were at war and they needed to clear out this underbrush and just go at it under the inherent powers of a president who is the second article in the Constitution. And although that had massive ramifications for the lawyers all over, it wasn't a principally legal, in my judgment, a legal argument that led them there. It was a prudential argument that led them there.
Yeah, I don't know how prudent it was, but I mean, there was also the problem of, and I say this as somebody quite sympathetic to the Article 2 arguments, there is Article 1, Section 8, which gives the Congress power to regulate interstate commerce, which includes telecommunications. So, I mean, there were a lot of very difficult problems getting into, what do you tactically, what do you lose by going to the Hill in terms of letting information escape versus what I thought was a strategic imperative of uniting the country. And it strikes me that sacrificing strategic goals for tactical ones is inherently foolish by definition. But
I know we could get into that. I mean, I actually think you and I come out with similar places.
And we may get back to that. But let me just sum this up by quoting Bob Gates, who said to me when I was his general counsel, I want the full range of your advice, but I want you to tell me what's policy and what's law. So I think what he was doing there was to point out that there's a difference between simply counsel, the consigliere function that you mentioned, Joel, and black letter. The problem, of course, Mary, that you're pointing to, and I think you'd agree, is that there's not a lot of black letter law in some of the areas that a lawyer has to counsel on when we get into some of the more novel national security areas.
Can I just, a word on that? I mean, I absolutely agree with that, and that's one thing that I think is one of the most important things that lawyers in this area have to remember is, in my experience in this last time around, I was surprised by how seldom there was just a yes or no answer. It's really quite, it's not that common. And particularly, in the kind of really hard legal questions that, end up coming up to the president, or to the White House level. And so you need to, be able to give the legal advice, say what the options are, if there are options, but and then give judgments, but make it clear that that's what it is. This isn't, I'm telling you can't do that. I'm telling you these are the ramifications. This is the precedent you're setting. This is the way you'll be criticized. And you can even say, I do think you should do it, or I don't think you should do it, but make it clear that you're giving us a policy view and not a, you are prevented from doing this.
I assume that was when he was at CIA during the Cold War.
Well, this was after the Cold War.
All right, so it was, my experience is in Mary, that these things were rarely black or white. I mean, it was sort of, the arguments came down to, is the power we're at our zenith or not here? I mean, there's someone, I'm sure, I think Jackson, right. So yeah, those are often the character of the arguments. Was never, I mean, there were sometimes it's crystal clear, but it was mostly shades of gray.
Well, Richard, let's use that kind of as a segue to talk a little bit about what the tension is between more traditional law that's developed in the domestic context. Earlier on, you were talking about law enforcement tactics, steps, and so forth, versus that law that is perhaps less refined in the traditional national security area. Now, from a domestic perspective, and particularly looking at one of the harder areas because it is borderless, what about the whole cyber threat? What do we do about figuring out what the law ought to be there, and how does advice get translated into policy?
Joel's a great expert on this. This is a huge area. We could easily do a whole conference on this one. Of course, the one major effort to actually get some new law in this area failed in the current Congress, and they're now looking at what can be done under executive. I actually think Joel put his finger on it, which is Congress does regulate domestic industry, and the telecommunications sector is intensively regulated. Those regulations are not largely the result of any national security calculus, although it's come into it, and has created, and I'm oversimplifying here, a massive regulatory and legal morass that is almost impenetrable for poor cybersecurity policymaker comes along and wants to try to make it better. I will point in particular to one thing, which is the 1986 liability limitation for internet service providers and telecommunications companies, which essentially holds them harmless for both the bugginess of their code and for anything they may transmit. But that was done in 1986 to encourage the competitiveness and development of the U.S. telecommunications industry. And it worked as a very successful segment. But what it's done is taken the single most important private sector entities for cybersecurity completely out of the equation because they have none of the normal incentive structure to do the safe and prudent things for the system as a whole. They just look out after their own interests because there is no tort and liability claims that are ever made against them. It would be as if the automakers had no responsibility to do seatbelts or airbags or bumpers. And that's how it is for Verizon and Comcast and Microsoft and cloud providers and the rest. And so this is an area where an old set of laws written for a different age that now basically can't be amended for lots of things become the impediment to doing larger initiatives that might deal with a current problem that wasn't even imagined 30 years ago.
Can you add a little bit of further light to that problem, Joel?
Sure. Look at 18 U.S.C. section 2511. If you ask an ISP why it doesn't take down botnets, which it has ample evidence of, the answer you get, if you can get somebody to talk to you, which is down is privacy. We don't do that. Invasion of privacy. What do you mean? Well, 18 U.S.C. 2511 says that we can't interfere at all with any communication unless there's an exception. It's a service provider exception in that statute. I don't remember the subsection name. Unless it's in order to protect our own network. And they interpret that to mean, well, if it's going to mess up and keep our network from functioning, we can do it. But if it's going to keep one of your subscribers from being infected, we can't touch it. I think this is foolishness, although I wasn't successful in trying to get the Justice Department to take this issue on directly. And it won't be litigated if an ISP, one of the carriers, doesn't want to litigate it. But what they're really saying is, if some of this garbage goes through our system, into your system, Elizabeth, no skin off our knee, and we're not gonna tell you about it, even though, gosh, when you send an email to me, I'd really like to know if you've got a corrupt system, if you're on a botnet, because you're gonna be infecting me. They don't do it. I think that's one of the things Richard's talking about.
You and I are totally in sync on this.
And it's really quite appalling. They don't wanna be restricted in any way. They wanna be neutral pipes, whatever flows through, garbage in, it doesn't matter. That's the problem, fundamental.
So Mary, do you want to comment on the whole cyber problem?
Well, I mean, I think it is, sort of a classic. It's an area of law that is, or it's a subject matter that is ahead of or behind or somehow, not yet hasn't been synced up with the law entirely. It's very complicated. The policy, the technology, and the law are all developing. There are a number of areas where the answer just is we need to change, new legislation, and that of course is quite difficult because there are a lot of different views on on all of these issues. They're very controversial, but I think in general, I mean, one thing sort of more generally that I would say about how to address areas of law like this, and I'm thinking more here not on this domestic side as much as, one of the big questions is what is the use of force in cyberspace, and how does that develop? And I think, there's a difference of opinion of whether you, the government lawyers, should be trying to develop an entire kind of full theory and of how legal framework and sort of plug the current question into it, but also deal with questions that are at the time hypothetical, or do you try to build it, kind of incrementally, dealing with the questions that you have, and try to build, have the new way to address the law build up incrementally. Probably tell from the way I just presented that my view is building it, dealing with these questions incrementally is the right way to go, and that you might, if you're trying to develop an entire framework, answer a question that's a very hard question that never will actually arise factually. And there are benefits to having the framework because you know where you're going, but I think the sort of more modest, incremental approach to leaving flexibility, trying to look ahead and understand what you're, if you're answering a particular question, what are the ramifications of that, but not trying to sort of answer all of the questions.
So Richard, as a client, this must be very frustrating because on the one hand, we have domestically a very rigid set of laws that really drive and control policy, and yet Mary makes reference to cyber warfare. Well, presumably we don't have the same legal framework governing that, and so you're into an open here.
Right.
So how do you put those two together?
If we were ever in a shooting war with China and they were taking down our satellites using the ISPs, in that emergency situation, I think it would come off. But in the absence of, we would act, sort of aggressively and spasmodically. In the absence of that, which is where we are, the problem is that U.S. telecommunications law has developed already, and it calcified and encrusted in a way that now resists change to new technology or new national security threats, and it's immensely difficult to affect. I want to connect, though, to a current policy debate, which is the failure of the cybersecurity bill has led to a lot of talk about a cyber executive order, cybersecurity executive order. This illustrates for this audience exactly the problem, which is if I were the client now, I would be outraged. I mean, I'm now in the National Security Council, say, and I'm going to say, wait a minute, why did I waste 3 years of governing if there were things I could have done with an executive order, knowing that, and not do them back then, and do them now only after the legislation comes? Meaning, if there are things you can do with existing authorities, and creating a voluntary information sharing standard can be done with existing authorities. It's voluntary, after all. You should have done them back at the beginning of the administration, not wait for Congress to thrash it out and fail, and then do it a week before the debates. I mean, it should have been done, if it were lawful to do early, you should have done it then. And we only should have asked things from Congress that we couldn't do with existing authorities. And that to me was a fundamental failure in that element of the cybersecurity policy.
You're saying that the selection of an approach, a legal approach, really had significant policy implications.
In this case, if there was anything material that the administration could have done under existing authorities in 2009 or 2007, for that matter, without asking for Congress to do it, they should have done it. And it's like, and there's certain things they can't do where you need legislation, but I would be very parsimonious in what I asked Congress for. I wouldn't ask for more than I actually needed to do things, and I wouldn't ask it to just take my authority to bring it to the zenith rather than not here.
So what do you say to this angry client?
Well, I mean, you know,
Well,
on this
there you
particular
go.
case, I mean, I think the answer probably is this is not exactly what they wanted to do, and there was more that they wanted to do, and they needed legislation for it. But you know, this is the backup, you know, so without actually, you know, knowing specifically what's the executive, or my understanding is that the leaked, what's leaked of it, it sounds fairly narrow, and the legislation certainly is much more ambitious.
Joe, you want to comment?
Can I go back to your original, way you originally formed the question that led into the stem for this conversation, which was, I think, about how it is we understand and think about the cyber business in general. You said something very important, Elizabeth, at the beginning about why law schools are really important in this area. Most of the country and most lawyers don't understand how the telecommunications system works. And when we talk about cyber interceptions, most people still think of those scenes from 1940s black and white movies with a cop in the wire closet with alligator clips in the, in the basement of the apartment building. That's not how it's done. We don't have circuit switch telecommunications, and we haven't had them for decades. We have packet switch communications, which travel largely either through the air or principally now in fiber optic cables. And the process of intercepting communications is very, very different. Under the old FISA law, we weren't in many cases protecting privacy at all. We were regulating the place at which things could be intercepted and the mode of communications. Let me give you an example. A lot of international telecommunications which do not either start or end in the United States touch the United States at one of our coasts. Under the old FISA law, in order to intercept such a communication, even though it was nothing but international communication, both ends international, we needed a FISA warrant. That was fixed in the, that didn't protect, by the way, that same communication, if we could have picked it up in Saudi Arabia or Nairobi or Caracas, nobody would have blinked an eye. It involved two foreigners at both ends of the call, but we were regulating it under FISA. Of course, if they had communicated in a different way, it wouldn't have been regulated by the telecommunications, by FISA at all. So we were only regulating the communication because of the way it was conducted and where we picked it up. The country still doesn't understand that. And the country now, people who pay attention to this think that what we've got now is some big sifting mechanism by which we're picking up lots of U.S. person communications. If the FISA court wants to authorize communications that principally, through a channel that principally come from country X overseas, it's going to have to impose some filtering order of business on that program in order to take out of it any communication that might involve U.S. persons. This is a very complicated thing to do. You can't go into one of these pipes with wire clips and pick out ABC, and the NSA or CIA or any of our other agencies is entitled to pick up international communications without any kind of warrant or order. The country doesn't begin to understand this sort of problem. So the debate about what is reasonable, fair, honest, and so forth, has missed the public entirely. And I think it's missed in a lot of law schools as well. And since we are in a seminar on teaching law and national security, I'm reading off a copy of the paper bill, I ought to say that I don't think it's too blunt to say the failure of most law schools to mix the computer scientists, the policymakers, the EE engineers, and the lawyers in one room to deal with this issue set is a significant problem. And that the best conversations that take place, whether in NSA or in a university, about how to regulate this kind of interception program or how to regulate telecommunications in general only occurs when that group of people are all in together in one room. And I emphasize, this is also true at NSA, where the lawyers are, as lawyers go, quite smart about these things, but still, I mean, some of the arcana of this subject is very, very difficult. You've got to get the people in the room who really understand, Chief, that's how it's collected. This is what really happens when we do this.
But so Joel and I lived through this from different vantage points. The story he tells about this is exactly right, but there's a really fundamental point for this audience to get from it, which is the way the Bush administration tackled that problem was exactly wrong. And exactly the correct objective. But this was known, it's well known that the law was written in a way that made the kind of intercepts that Joel's talking about require a FISA warrant when they really shouldn't, because the people involved, it was basically foreign intelligence. But it was an accident of legislative drafting from the 80s or 90s. And everyone knew it needed to be fixed. President Bush elected to fix it by a secret executive order that not even the Deputy Attorney General had the clearance to see, which later was leaked, and that leak investigation is still going on. Led to a big blow-up, and lots of controversy and mistrust and allegations of lying and whatnot. And then 2 years later, the Congress passed a law that essentially enshrined in law exactly what the president had done 5 years earlier by secret executive order. Whoever, I think I know who it was, whoever cooked up the idea of doing that by secret executive order at a time, I was running legislative affairs for lots of national security and homeland security counterterrorism
We know
stuff.
that guy.
And I know the guy. But at that time, the 15 months between 9/11 and the midterm election, that administration got anything it wanted through Congress with no trouble whatsoever, basically. And if we had merely just said, let's just fold this into the latest legislative vehicle that's moving, and there were tons of legislative vehicles back then, and fix this one little problem, there was so much storm withdrawing would have been eliminated. And so for the lawyers around, like, that's a good lesson of like how not to do it. When the client knows the objective, but they go about it in a way that is deeply counterproductive.
Well, I think, Richard, there's another point here to flip it around. I'm glad you teased this out, the two of you. And that is that the clients have got to recognize that law is going to be embedded in much more of what we're doing today than what historically might have been the case. And there, I think, and I'm going to go back to the client side and ask you a question, and here I'll allude to my own experience. Many years ago, I was at an event with two of the smartest people in Washington, if you don't quote me, Bob Gates and Les Aspin. And we had just finished looking at a report on the future of intelligence that Georgetown had put out. And I said, over cocktails, gee, the one thing this doesn't seem to talk about is law enforcement and intelligence. Now, when you're a woman and you say that to two men and they don't respond to you, you think one of three things. I spoke in a foreign language. I said something that must have been so foolish that no one even wants to acknowledge it, or that's just the way women respond to men, or men to women, pardon me. I did the same thing at dinner, same reaction. What do I take from this? I take from it that there is a major divide in our understanding and thinking. Now, those two guys began to get it. But I think still today, there's a real misunderstanding that we are going to have to deal with law, whether it's overseas or domestically. And then on the one hand, our lawyers have got to, as these two good examples of a fine lawyer would tell us, be in the how do I get to a yes, how do I get to solutions. But the client side has got to understand that you're going to have to deal with law. And the kind of advice you've just alluded to is you can just thumb your nose at a legal structure, system, and process. There's another side that's a little less, what shall I say, negative in its description, and that is that I think many policymakers are very uncomfortable with what the legal framework is. So on the one hand, we have lawyers who don't really understand the difference between domestic and national security law, and we have clients who are similarly, although they're on the national security side, unclear as how the two halves work together. With that long introduction, a question for you, Richard, and then maybe comments from Joel and Mary. In my day, there was great tension between law enforcement and intelligence, as my little story suggests. Are we now at a point where the two halves of this security puzzle are working together seamlessly?
Not seamlessly. And they'll never be seamless. They'll never be perfectly seamless, in part because, law enforcement occasionally busts into your office and walks you out in handcuffs and arrests you for corruption or violation of civil liberties order. So there's always a tension. You got to talk to the CI people, and why did they think the way they do about FBI? They'll often talk about the terrible experience they had with the FBI trooping in with the Aldrich Ames investigation. I think it was Ames. Maybe it was Ames. So they're never, particularly the FBI. The FBI is the ultimate arbiter of public integrity in this country. For both federal officials, think of Abscam, the 1970s thing when they did a sting operation against a sitting member of Congress, and state and local. So they're never your buddies. You always are a little worried that they might actually have a wiretap up on you, and they're going to, people, that happens. So they're never really that chummy. But it's a lot better. And it is by no means perfect. They operate under entirely separate legal doctrines. Their cultures are very different. But and there are going to be problems, going to come up again and again. But after 11 years at this, I think it's much better oiled. Issues come up all the time. I mean, there's no question. They come up operationally. They come up policy-wise. They now mostly are sufficiently well socialized to know they can't openly ignore each other and fight with each other in front of their supervisors. I mean, they have to get along. Whereas in the old days they could just not look at each other. One of the reasons that National Counterterrorism Center got created was George Tenet and Bob Mueller, who would come brief George W. Bush every morning after 9/11, kept surprising one another in front of the other. And the aide, I witnessed probably half a dozen times. The aides would get this. You realize they just did this, but they were both polite enough not to start yelling at each other in front of the. But they would wait till they went out into the foyer and then have at it. And each of the guys, you really got to stop this. I mean, this isn't going to work anymore. And at one point, the president said, "Are you guys talking?" And that led to the creation of the Terrorist Threat Integration Center in the State of the Union in January 2003, which was enough to get NCTC started, but later was enshrined by the national. So there will always be problems in this. It will never be seamless. It can't be structurally. They just are in different cones, but it can be managed and a lot better than it was before.
Very helpful. Joel and then Mary.
Yeah, I agree with Richard's take. I would add to that that the problem is very much like integration in the military. It took us almost 50 years to get the Defense Department to be able to mount joint operations. And for those of you who don't know the story of the Goldwater-Nichols Act, Victory on the Potomac is a stupendously good book. And it's very difficult to believe that
this audience may not know what the Goldwater-Nichols Act is either.
That's the act that created joint commands that relegated the service secretaries to the role of recruit, train, and equip as opposed to running operations. Got that right, Tia? Mm-hmm. And it set up joint commands covering the globe, to simplify. You now have people with Army, Navy, Air Force, Marine, Coast Guard uniforms serving in the same watch centers, serving in the same, on the ground, boots on the ground together in joint operations seamlessly. It's quite marvelous. It took half a century to get the rules to do it, and it took another 10 or 20 years to get it to work seamlessly. We've got a similar problem in the intelligence business without a statute that compels it. But one of the things that I think a sine qua non of Goldwater-Nichols working was the principle of joint service. As a former DNI told me, when he had been a young Navy officer, if he had said he wanted to go serve in an Army billet, he would not have been promoted. He would not have been promoted. After Goldwater-Nichols was passed, with the provision that you cannot become a general officer unless you've done qualified joint service, there was a rush to do that kind of work. In the intelligence business now, there has been, since '04, a component of joint service that's not statutorily mandated. Once the guys in the Bureau can call up somebody in the CIA or somewhere else, or NSA, who used to sit in a desk next to him because he was on joint service, this will begin to run smoothly. It doesn't matter, the laws are what they are. Unless there's personal trust among people, it doesn't really work perfectly. We are much better than where I agree with what Richard says, but it's not going to work better until joint service has become really robust and virtually, if not universal, then widespread.
I'm not going to hear.
Well, I agree with that. I think I was in the NSC just before 9/11, and then I was back in the beginning of the Obama administration. And one of the things that I, much was the same in terms of process and how things work, and much was different. One of the things that I think was really quite different was this: the integration and the intelligence and law enforcement working together. The attitude, the culture had, I think, not perfectly, but had really changed quite significantly. So I guess, the question is, how can we do that? Changing culture is very, very difficult. In Goldwater, with Goldwater-Nichols and part of the defense, it took an incredible amount of time. And in this case, I think, we had this wrenching national tragedy of 9/11 that really sped it up, but generally it's one of the hardest things to do is to change culture and get changes like the one that they've been describing. And even to get, the situation where somebody thinks it's a good idea and actually makes a move to put two people in the same office so they can communicate and learn to work together, the incentive to do that, is not there typically unless you've got legislation and time or some kind of major event.
Okay.
Like in the New York Police Department and the FBI.
Right, there you go. Before we move to the audience, so get ready for some questions because I want to give you a chance, this wonderful panel too. Let me just kind of summarize this and then ask you each a final question. I think really what you're saying, Richard, is that rules, roles, responsibilities ultimately combine to produce different cultures, and that unless you're a cross-cultural anthropologist and you're capable of understanding what that other person's role in it all is, you are not going to be able to work effectively together. And I think that's probably true on the policy side as well, because we have policymakers who are domestically positioned as well as policymakers who are in traditional international security. But now, here's my question. What about the private sector? Each of you is no longer in government. You're doing things on the private side. How do they fit into a new national security paradigm? It's a trick question.
They make a lot of money from it. It's like a big consulting and selling to the federal government. I mean, it is ballooned beyond all recognition. I mean, I think the first point is we have overreached in the scale of our military-industrial intelligence complex. It's ridiculous the amount of money that we throw at some of these activities, way beyond real mission criticality.
So I'm not sure I understand exactly what the question is. What is the role of the private sector?
Is there a role for it? Traditionally, we thought security is something we ask our military, our law enforcement authorities to take care of.
So absolutely. I mean, and the cyber area is one of the most. It is one of the most obvious examples where you've got most of what needs to be protected in the hands of the private sector, and one of the toughest issues we're sorting through is how to. I mean, and in part of the legislation, it's part of what this apparent effort in an executive order is dealing with, is how does the government kind of get, it's so much easier when the government could just do everything itself in the national security side, and it could, make all the decisions. Now you've got to try to, get the private sector to do what, to take actions, to secure their systems that aren't in their immediate economic interest, and it's extraordinarily difficult. So they play in that area and in many others a huge role in national security, and I think we haven't really sorted. We have not even begun to sort out how to address that and do it well. So, and you would be able to talk about that much.
How about your antitrust background? How does that fit in here?
Only in that the antitrust objections to sharing information in the private sector, I think, are a red herring. And setting up information exchanges with government's knowledge and approval that are well lawyered, that don't deal with pricing or territories or anything else, would be quite a simple thing to do. There isn't more information sharing because companies think they have a competitive advantage than knowing more than other companies do. That's what I think about that. But the change that, Mary, that you and Richard are talking about, I think is even more profound than the vast expenditure of money by the public sector on the private sector to help the public sector. For one thing, the private sector now is targeted systematically in espionage in ways that are really quite dramatically different than espionage for the millennia beforehand. And there are a number of reasons for that. The Chinese and the Russians figured out no later than 1991, with the first Gulf War and the collapse of the Soviet Union, that if you can't compete with the United States economically, you can't compete with us militarily or in any other way. And so catching up, and if necessary, stealing information from us has become a state-sponsored objective in both of those countries and in other countries. So that the private sector now is targeted for information not necessarily having anything to do with military or state affairs, just for economic secrets. This means that lawyers like me and consultants like Richard, maybe you, find ourselves giving advice and briefings to private executives of the like of which would not have been given outside of the government, maybe the exception of high officials at a place like General Dynamics, 10 years ago, let alone 30 years ago. This is a daily or certainly weekly event for me now. It's not only that the private sector is being targeted, there is more offensive intelligence now being gathered in and by the private sector for private sector clients than many people begin to understand. It is a robust, sophisticated line of work. And companies want to know where their dangers are. They hire private companies to do things that used to be only governments could do. Overhead surveillance, human intelligence embedded in particular groups, not just chat rooms, but those included. Every form of intelligence, just about every form of intelligence that the government uses, maybe with the exception of MAZIN and stuff like that, is now being actively exploited in the private sector. These are national security issues in many cases. And I don't think the teaching of national security has caught up with this. Correct me if I'm wrong.
And I think this is, I want to stay on this because I was intrigued by the antitrust dimension. I'll just offer one and then let you, on the antitrust side. There are certain aspects of the information economy which are have elements of being natural monopolies, which means one provider of it ends up winning because of, for reasons of economies of scale. So that's true of operating systems, it's true of data centers, of social media, of email, cloud servicing, of search. And what this means is that the handful of companies, and they're all household names, they're really big, end up developing information systems and architectures with detailed knowledge about the lives of their subscribers and their subscribers' associates, far in excess of anything the Bush administration ever did with intelligence in its wildest dreams. And they have permission from the user to use that for profit making in the terms of service that they sign with them. So what's happened is you now have a handful of US chartered private global companies in the IT sector who are surveillance states created with the permission of their subscribers. And targets. And targets. And we're both targets and occasionally become suborned and become agents of state surveillance. So it's a very interesting intersection of a trust issue, which has to do with the economies of scale and the natural monopolies in certain IT functions, and national security and what this means. Because arguably, there are 5 companies out there that know more about everyone in this room than the U.S. government does or ever will, by virtue of everything you post on all their social media sites and every email, all of which is exquisitely tagged and archived for the purpose of selling you ads, but can also be turned and used against you for other reasons.
Well, now, I had a different question as my final one in mind, but that's just too stimulating. So you're the policymaker. What do you want to do?
Well, so there's no way we can answer. One thing I do like is when they're really quick responding to my FISA warrants, because there's so much data that comes in these days when you serve a FISA warrant. You have no idea how, a FISA warrant gives you not just, it's not like, as Joel said, a guy with the little clips in the data room listening to current conversation. It is your entire historic archive. So that actually the power of that warrant has increased, in my judgment, exponentially because of the creation of these agencies, which are subject to U.S. law, and of course the law of the nations, other nations in which they operate, which when required to respond to a court order, turn over troves of data so vast and incredible about your targets, mind-boggling.
So you're happy with what your lawyers
Well, there's other problems too, but it is what it is. I'm just telling you one narrow aspect of this, that when you serve them a court order, lawful electronic surveillance, they are awesome collaborators.
Okay, final question, I promise. We're here hoping that we're reaching out to the academic community. What bit of advice would you give them? How are they doing today in terms of the kind of research and thinking that they're provoking? Does it help the policymaker, the lawyer serving the policymaker in a national security context? If not, what ought they to do? Maybe start.
I think that there's a lot of really tremendously helpful writing out there when you're in, particularly again when you've got these novel issues. Just all the time when I was, at the NSC, you've got cyber issues, you've got, targeting drones, all of the, in over the past 10 years, certainly, law of armed conflict and non-state actors and AUMF and all of these really, novel issues. And the lawyers in the government are just working constantly working so hard trying to deal with what's, that day's question, that you really don't have time to get ahead and to really kind of think about, the issues, a little bit more broadly. And so what there is a lot of out there now, and I really don't know whether it's new or has always been this way, but there's a lot of work by academics on the questions that are kind of a little bit ahead. Articles about the Title 10, Title 50 issues, and Ashley Deeks did one on unwilling and unable, and kind of really examining a question that comes up a lot. But when you're in a you're doing this day to day, you don't necessarily have the ability to dig in the way an academic can do. And there are a number of examples of really practical scholarly articles that have been, I think, are tremendously helpful. And then, of course, there are also the blogs, which are quite helpful.
It's good to hear, isn't it? Academics. Okay, Joe, how would you do?
I agree about the long-term thinking very, very much. You don't get a chance to do that as a practitioner in private practice or in the government. I've made a couple of specific suggestions I don't need to repeat. I think, though, that the core function is turning out students who can think and write well. And that's the most important thing. But I would add that multidisciplinary exposure, multidisciplinary thinking, and reading lots of books. Reading lots of books is what students need to do.
I agree with Joel that multidisciplinary thing is really important, reading and writing. In general, I'd say teach pragmatic skills. At this stage in their career, they don't need ideology anymore. They really need to learn how to function. If they're going to enter a government agency, they need a set of skills, some subject matter expertise, some reading, writing, speaking, all that. But be very, very pragmatic in the course of instruction and turn out fundamentally pragmatic people who want to go tackle and solve. You rarely solve the hard problems. Just tackle the hard problems and leave them a little bit better than they were when you found them.
And what about the faculty? Are they making contributions that you think are relevant to advancing our understanding and development of policy in a legal framework?
Hard to say across the board. More often the contribution comes from the direct entry into government of the person who did that work. So, like what Joel said, the benefit of lifelong deep studies, I don't actually know him, but I know he's talking to was Harold Coe in international law. I know his reputation. It's not, I'm sure he wrote a bunch of books and articles and stuff like that, right? The benefit is not that he wrote all those and other people in the Obama administration now read them, I think, because the president went to Harvard Law School and he taught at Yale. I think it's that he went in himself and is there with all that knowledge that he accumulated and is elected to give a period of his life, not with a cushy life as a dean, but like writing memos justifying this incredible level use of that the Obama administration did. But that to me,
we don't know.
That to me is the biggest contribution that are made by faculty. Not to say that the other contributions don't happen from time to time.
I'd like a pitch for public service here. I remember being asked when I left private practice to go to NSA. It really raised their eyebrows, especially when certain things started to happen and became known. But if you really want to test your principles, you got to go into the belly of the beast. If you really want to find out how you'll act when you have to make decisions and not rethink somebody else's decisions after the fact, you got to go into the belly of the beast. I don't say you have to go to NSA. You have to go where your principles are tested. You can do that in some cases in private practice, but there's nothing like the experience of having done that, bringing it back into academic life to enrich that experience, I think, enrich one's own life.
Well, time is short, but I'm sure there must be some questions. Steve Diamond.
This wonderful panel has dealt not much with law, but mostly with lawyering. We can't hope to help our students prepare for a career in this field without knowing something about how lawyers actually work, about their relations with their clients and so forth. Moreover, they can't really begin to understand how law itself is made and applied unless they get it about the sharing, responsibility, accountability, all of that you've been talking about. Unfortunately, none of the published judicial opinions or executive orders, statutes, the other stuff that Mike and we put in our case books deals with these issues. And so my question is, I know some of you have stood in front of a classroom. How do we convey this information to our students?
Who wants to go? Mary, you want to start?
I'm very new to teaching, and so I'm not sure I've got a great answer to that. I think it's quite important. I think Laura Donahue is going to be talking, I think, this weekend about crisis simulations, and I think that is a very important way, and using case studies, and playing roles. I think is one, I think, extremely useful way to do that. There may be others. It's hard. It is because there aren't case books on it, and you need clinics, but kind of really trying to put people in the practical, in the place to try to sort of think about the way they would have to think through the issues.
Strikes me as a good answer. What do you think, Joel?
First of all, thank you for articulating the difference between law and lawyers, lawyering problems and law problems. This is really the crux of it, Steve. I think we need to rethink the case method. We think of, as lawyers, of the case method as being about law cases, generally appellate cases. And there's great merit in that as a tool, but not the exclusive tool of legal education. If you go look at case methods in business schools, it's very different. For one thing, students are regularly put into teams in business schools all the time. Virtually all the work that goes on in the business schools I know is done in teams. There's very, very little testing even on an individual basis. And the cases involve not what the law means and what the judge meant and what the holding is and so on, but how do we behave in these situations? And I think this method can be adapted to some good effect in law schools.
Let's go to this questioner, and then Richard, I don't want to cut you out if you want to comment. Okay.
It's Tim Ed here. And I guess my question's on cyber. And I was wondering, because Mary DeRosa gave a great kind of explanation as to the dangers or the problems of trying to create a whole new framework when the old framework doesn't fit, and that maybe you should just confront problems as they go along. But I guess the problem with that I could see from the policy maker's point of view is that, when it's such an ill fit, maybe at a little bit of a loss as to what to do. And this may be an exception to the point where you don't want the policymaker asking the lawyer, what do you want me to do? Right? That's kind of the opposite of what you want. But in this case, it seems like that's one of the big problems is, the example I thought of when you were discussing this was you had a great discussion about what to do about if you capture somebody in Libya. And you sort of immediately went to, well, here's how we could use the criminal process, here's how we could use the law of armed conflict, and a good discussion there. And then when we got to the issue of the video, it was like, well, this is complicated, we don't want to do something dumb, we could end up violating all sorts of laws, First Amendment, telecommunications interception, all sorts of things like that. And then I'm thinking here as a policymaker, this is unsatisfying. I didn't get a menu of things I could use to try to solve this problem. Instead I got this is complicated and we can't do anything. I'm not trying to blame, I'm not trying to put in the spot.
I think I would have done a better job if I were actually, and I was trying to give an example.
I just think that it's not as mature. I think that that's my sense of it. Maybe I'm wrong, but I get the sense that we've had a lot of experience under fire in the law of counterterrorism. Cyber's a little bit newer in certain ways. Do you think there's a case to be made for having a more systemic look, perhaps with the aid of the Legal Academy in this area, instead of waiting for problems to develop and doing it incrementally?
I absolutely. I don't want to overstate that point. The point that I made. I don't mean just pretend nothing happened until you get a problem and then just deal with that and kind of. Obviously you need to be thinking more broadly. You need to be thinking systemically, and there's cyber is a tremendous amount of work and it's very useful. I didn't mean to say don't think about that at all. I think that there is a benefit to retaining some flexibility and not going too far, because there might be consequences if you're making legal decisions about something where you don't have the facts. You're just not going to do it. You're just not going to do it as well as you can, and you could end up limiting options later that you didn't need to. So I don't want to overstate that point, but I think it's important to not try to answer the full range of possible questions.
Because you'll say no to things that you could have done a different way.
Right.
But I would interject here that doing a systemic look at the law and as how it affects cyber, both domestically and internationally, could be very, very valuable.
Oh,
I think there's a great thirst for that beyond Mary's prudential observations. I want to do equal opportunity questions, so over this.
Yeah, the question is for Richard. You were talking about ISP immunity, and first of all, I had to decode what you're saying. You're talking about a 1986 law. I think you mean Section 230. Is that what you're talking about?
Now you got me.
That's
I only go to the year in the law, I don't know the sections.
That's 1996.
No, I'm talking about the act,
Oh, you're talking about the Electronic Communications
Yeah,
Privacy?
yeah, that's what he's talking about.
Okay, because you're talking about immunity, and I just wanted to put in a good word for ISP immunity, because the Section 230 and a lot of the immunities that you're talking about have nothing to do with botnets or malware. They have to do with content. And with not making the service provider responsible for the content. And that is, of course, what has enabled the entire social media explosion, YouTube and so on. It's sort of like, if you want to use an older analogy, you don't want to ask a telephone company to be responsible because I picked up the phone and plotted a bomb threat. You want the police to handle that, right? You don't want the telephone company to be trying to detect that, otherwise you're encouraging them to be spying on everybody all the time and making decisions that protect them rather than protecting freedom of communication. And I think the thing that makes me want to comment about that is that the national security community tends to think only about national security and not about the sources of economic competitiveness and innovation that actually make us strong.
It's a diverse community, and people are able to move across. I mean, it's not. There are people in what we call the national security community who are able to think about economic competitiveness simultaneously. If I were to distill this to its essence, and that's not a productive time to figure out which section of law to say, the role of the U.S. government in protecting non-U.S. government-owned networks and non-U.S. government-owned data in the United States is highly unsettled, both in terms of what is the U.S. government authorized to do vis-a-vis the owners and temporary purveyors of that data, like the ISPs, and what should the U.S. government be trying to do at what cost to whom. And that is up for grabs right now. To your point, of course this should be carefully studied. And we need to get smarter on it in its breadth, but have no illusions there's any chance of it being enacted as a whole new framework. It will be done piecemeal, but as an area of study, of course it should be studied.
And until we begin to broaden the base of those who are deeply understanding of it, I think we're not going to make the kind of headway we need. And that would be my point. Now, are there other questions? I think we're a little over time, but maybe you'll indulge.
You can take a little more. We have a long break.
Okay. Did I see another
Couple
hand?
more questions.
Okay, Ed.
Returning to the teaching this in the classroom, I was really struck when you said the packet switch difference, because I don't know how other people deal with that. That's my starting point, as a Choctaw on the move to the packet switch world and the implications, and then that the federal government's role in surveillance is becoming increasingly less relevant because Big Brother is the private world. But is that what other people do? Is that what the threat of national security? Because you say, Steve, you don't see any of that in the cases. When you look at the cases and the legal stuff, you still think it's between the government and private individuals. But in fact, the government's almost irrelevant. Private companies collect all the info. How can we bring more of that in? Are there materials, or if other people aren't doing that, are there materials they can use to do it? How can we sort of readdress our traditional individual versus government and realize it's private company versus individual government getting information from the private company?
Did you want to respond to this? Because if not, okay.
Yes, I think that there are some cases that are coming out. The Jones case, Sotomayor's concurrent opinion goes directly to the issue you're talking about. And in the book, the Warshak case, which raises it, it's just emerging into the courts. And I think it's very important that we make sure the students know what the law is. But you're entirely correct, and I think we see this in all the disciplines, not just the national security discipline. Knowing the facts of the client's business is so critical, and understanding those facts for applying the law. But I think that we need to make sure that the students really understand the state of the law as it is today, as it's developed. So there are some cases starting to emerge, and I think you're going to see, after June, more and more of the course looking at those. When you read through Sotomayor's
well, we can see the European materials because they treat it differently. They actually care about this private collection.
You know, I almost think the European materials are confusing for our students. A lot has to do with the way they write their opinions and everything else, and their law is very different, starts from different premises. So I guess it depends on where the student is in his or her development. But I think focusing on the U.S. law and the U.S. development is, and I think the casebook does a pretty good job at seeing how the courts react to technological change.
But let me interject here, as one who was a practitioner of national security law for the better part of 12 years. One of the things that I have reflected on since that time is how modest a contribution case law gives us. There isn't a great deal relative to other areas, and herein lies the challenge. And that's, I think, why lawyering in this particular context is really fraught with unusual problems. And so the suggestion that Joel made, that we use this particular substantive area, responding to Steve's question, to create more of a case study model on the business school model, I think is really a brilliant contribution. I had not really thought about that, but I do think that would be very, very helpful. And it would also, I think, force us to anticipate questions which may one day arrive in the courts. But the difficulty is that the vehicle for bringing an issue to court is much less well-developed and always will be. And of course, some courts will not go into this area at its most significant because they say, well, that's just not an appropriate topic for us to consider. I'm going to come back to you, but I want to make sure that no one else has an observation or comment at this point. Okay.
Elizabeth, I would like to push back a little bit on this business school model. I don't think the business schools in this country have done such a spectacular job. And I say that in all seriousness. I mean, here we have a financial system that is heavily populated with the graduates of the finest business schools in this country. So I do think that there is a place for modeling and scenarios and case studies, but we need to make sure that they don't become political science social experiments where there are no limits. People need to understand very strictly that there are limits in what law exists. And so I think when we create these case studies, they need to be much more structured than what some of the business school model is. I'd be hesitant.
Charlie, just for the record, I want to just say that I wasn't, suggesting teaching Ayn Rand or inculcating rampant selfishness in law school curriculums. I want to say that since it seems to have been misunderstood on that point. I was simply suggesting expanding the case method to look at how problems develop and how they're dealt with going forward rather than retroactively after they hit the appeals courts.
And another reason I would second that thought, although no one would disagree about the fact that there is a problem in the way in which our business school will seem to have produced without much ethical content their graduates.
Or legal content.
Yeah. But part of the problem, too, is that there's a huge timeline in when these matters may actually make it to court, where you can have that kind of analytic framework to help you. And the other problem is that some issues will simply never be joined. And yet you're going to have to look at them. And this is frankly a real problem, a burden for the intelligence community lawyer, because you cannot cite as readily as another lawyer could to why you say don't do this, do it this way, and so on. The authority is not there. You're extrapolating from things you know and that you think apply in a given setting. So I think it's part of the problem I think we saw in the early Bush administration. Just find a case, the fact that it's a 1942 case and much has changed since then, doesn't matter, we'll just apply it here. Now that's an extreme example, but.
We could go on with this, but if you read the Margolis memo, in a lot of detail, part of the problem was they did cite all the cases. I think that's the piece that came out of it.
And there weren't enough, because there hasn't been the kind of reflective contribution by judges that is so valuable. It's just modest when we come to intelligence. Well, that's my view. You and I are going to have a drink later on. Continue our debate.
Please join me in thanking this wonderful panel.